Good afternoon, everybody. I know that we are a little bit of a different time today. Usually we try to do the Sunday show earlier, like around 11 o'clock in the morning. But there's a reason why today we had to do the show a little bit later. And that's because there's a time difference between myself and our very special guest, as you know. So I don't want to make our guest wake up at 6 o'clock in the morning on a Sunday morning. Although this time may conflict with some of the football programs out there, but come on. I mean, believe it, you can just record whatever football team you're watching, because this is going to be obviously much more important and much more entertaining, by the way, I think, and educational than whatever you're going to be seeing on the football screen. So you just pause that, record it. We got all the equipment, everything that you need in today's day and age to record that football game, and you can watch it later. But today we are joined by a extremely special guest. And before I bring him on, I mean, I think this is just something that we've all noticed. Anyone who's been following the Karen Reed case, anyone who's been following Alan Jackson and everything that's going on with his new high-profile case, which we're going to get into today as well, is that he doesn't come on many shows. I mean, you know, we know that David Yannetti and Robert Alessi were kind enough to kind of do like a little bit of a law tube tour, and they came onto my show and a bunch of other shows, but not Alan Jackson. Alan didn't. And he's apparently very selective about which show he goes on. And I probably, like every other law tuber out there and every other TV station, reached out to Alan Jackson at some point afterward the trial and said, hey, would you be willing to come onto my show? And I thought, okay, I'm just going to throw my hat into the ring. You know, nothing's going to happen probably, but you got to try, right? You don't, what do you say? 100% of the shots that you don't take, you miss. And then I got a response. And Alan was willing to come onto my show, my little humble show right here. So I don't know why, but I'm extremely humbled. I'm extremely honored, and I'm fortunate. I'm very grateful for Alan. So without any further ado, let's bring Alan onto the show and let's get cooking with everything that we need to speak about. Alan, thank you so much for joining. I'm really, I'm shocked. I'm humbled. I mean, I don't know why, from all the channels, all the TV stations that were probably knocking down your door and flooding your email box, you agreed to come onto my show. So I'm just extremely grateful, and I very much appreciate you joining.
You're far too humble. You do a great job. One of the things I've always admired about your show is that you dig into the details, and I think oftentimes that's what's missing. A lot of the YouTubers, your colleagues, are very, very good at it as well. So I'm thrilled to be able to come on the show and talk a little bit about the details. And you like to get into the granular legal stuff, and that's my bailiwick. That's what I like as well. It's fun to do a talk show where people are sort of staying more at the surface level, but that's not really my jam. I like to get into the granular details, the legal reasons why we do certain things, the strategies behind it. So you're extremely facile at that kind of conversation. So it's my pleasure to be here. Thanks for having me.
Yeah, good. I appreciate that. And I think it's good because I think a lot of people, when they see you, they see the flash, they see how well spoken you are. They see
flash. I don't have any flash. What are you talking about?
And they don't realize that underneath all that is a very intelligent, effective attorney who's very well versed in the law. So,
well, thank you.
So that's what I like to get into, and I know that you like to get into too. So before we jump into it, and I want to talk about a number of different topics, and I know you got a busy day today. Also, I know you got some other shows you're going on, but I want to ask you just one question. This is on a different case than I'm covering. You probably maybe didn't even hear about this case, but I just have one simple question. And that is, you've been doing criminal law for a long time, right?
Yeah.
And you've been on the prosecution side, you've been on the defense side. So my question to you is, have you ever had a client as a defense attorney, or maybe a defendant for if you're prosecuting a certain defendant who was out on bond, did not violate the bond, and nevertheless, the judge, for whatever reason, revoked that person's bond?
So you're saying that the individual did not have a hearing, the court made no factual finding of a violation of the terms and conditions of a bond?
There is no there's no finding at all that the person violated the bond. It wasn't a hearing on a violation of a bond. It was actually a hearing on, there was a motion that was filed to modify a certain bond restrictions, but everybody agrees at that hearing that there was no violation. This was just,
she was in compliance.
She was in compliance 100%. They just wanted to modify the bond, and the judge just said, no, we're locking her up.
I've never heard of such a thing. That sounds outrageous. Why? What's the predicate for the revocation? That doesn't make any sense. There has to be due process involved in that. The person has to have a hearing. The court has to be able to make a factual finding on the record. That factual finding has to be appealable, which means you've got to have a full-throated hearing on the matter. The defendant has a right to call witnesses. But was the prosecution actually pushing for the revocation, or was this more judicial temperament issue?
No, I mean, what happened was, and I know we're going to get into other issues, but what I know what happened is that this was a case actually in Massachusetts, your favorite state, where this was a defendant who was not able to blow into a scram device to test for her alcohol.
Physically unable?
She was physically unable. She was shot. She was actually shot in the chest, and she had broken ribs and all types of internal organ problems and injuries. And she would be able, I mean, eventually she'd be able to blow into the scram device, but it would cause her hours of pain and dizziness, excruciating pain. And her attorney just simply filed a motion to modify the bond. And at that hearing, the judge got so upset that she cannot comply with this scram device, blowing into the scram device, that she said, well, if she can't comply with the conditions, then we're going to have to just right now, sua sponte, we're just going to revoke her bond and throw her in jail. Have a nice day.
That's outrageous. It's outrageous. It's like saying if one of the conditions of your bond is that you have to give me a right thumbprint on some document, and your thumb has been amputated. You don't have a right thumb. Oh, well, in that case, then I'm going to throw you in jail. That's outrageous. It makes no sense. It does not seem to follow the predicates of due process. So no, I've never heard of such a thing.
Yeah,
in case you're wondering, no, ever.
This is what's going on in Massachusetts. So I'm
wow.
sure you're not.
Wow.
Okay.
Who's the defense attorney handling
the defense attorney is Timothy Bradel. You familiar with him?
I love Tim. Yeah, I'm familiar with him. He's a fantastic lawyer, and I guarantee he is not going. I know Tim. He is not going to take this sitting down.
They're in the middle of appealing it to the. They already filed a motion for reconsideration.
Good.
They appealed it to the single justice, and now they're going to the full bench, and hopefully we'll get a decision soon, and she'll be let out of jail. I mean,
it sounds pretty outrageous to me, and it sounds like a layup in terms of the law. The law says she's entitled to due process. It's not a failure. It's not a willful failure to comply. It's a physical inability to do something.
Exactly. So I'm completely with you, and the people on the channel know that I'm outraged about this case as well, and hopefully we'll hear some good news about it soon.
I hope so.
So, Alan, let's get into a little bit. We're going to touch a little bit on the Karen Read civil case. I think I wouldn't be able to have you on and be forgiven by everybody if I don't ask you, how's Karen doing? How's she holding up?
She's great. She's great. She's doing very, very well. I've always said in every opportunity, in every forum that I've had an opportunity to talk about Karen from a personal standpoint, she's as strong a person as I think I've ever met. So she's doing very, very well. She knows that she's got another fight on her hands, but she's got her back up and she's ready to take it on. We've got all the facts and the evidence in our favor. So we're not backing down. She's not backing down. Yeah.
I mean, it seems like after, 3 years of what she went through, 2 trials, that's enough. And now it seems like it's never ending. Now she's getting.
You would think so. Yeah, you would think so. But, powers that be in Massachusetts have decided otherwise, and they wanted to pick a fight. So we're ready.
Yeah. I mean, so number one, they're posturing. Again, we don't have to get into this so much, but again, they're posturing to go looking through her phone to perhaps bring her back to a grand jury to try to stick some witness intimidation charges on her. That's one thing she's got to worry about. Another thing is she's got this civil case that she's defending, the wrongful death and all that nonsense. And then I just saw recently that there's this opposition, this non-party, Jennifer McCabe, Matthew McCabe, Nicole Albert, all those guys, all the gang, their opposition, and then them hinting that they're going to file a defamation lawsuit against Karen and a certain blogger. So. It just doesn't end. Like, when are they going to leave her alone?
Right. Exactly. That's what we keep asking. But until they do, we're right here fighting right with her. So it is interesting. The turn of events that occurred on at the last hearing, the Zoom hearing that we had, talking about that exact thing. Are the cases going to be consolidated? Because she's getting up on the balls of her feet. She's actually suing individuals. She's not just going to sit there and be on the defensive. She's going to be on the offensive. She is now on the offensive. There are other parties that are going to end up being brought into the case. It's her case as well. The original thought was, it makes sense because all the same parties, all the same evidence, all the same arguments are going to be propounded in either one of the cases. In both of the cases, they should be combined. It made sense to combine them. The civil lawyers, Damon Seligson, when he made his first introduction about this issue to the judge, he said as much and said, our intention with the court's permission is we think that we should combine these things because otherwise we're going to take 2 depositions for every single person. I think a light just went out. 2 depositions for every single person that is on the witness list, and interrogatories, and all the discovery is going to be duplicated. So it doesn't make any sense. That said, I think we're going to have to go without the light. That said, it didn't make sense for us to do this separately. So we made the pitch. The next thing you know, they oppose it in the opposition that you're talking about. So we said, okay, fine. Then we'll just sue individually. We'll sue in a different county and put on an active lawsuit that is to our liking. She becomes the plaintiff, and these individuals that have been named become the defendants. Well, the next thing you know, we go back into court, and the argument that is then propounded by opposing counsel is, well, wait a minute, why aren't we putting these things together? Which is exactly where we started from. So I felt like I was a little bit in Alice in Wonderland, but we'll get to the bottom of it. These are procedural niceties that are not going to inhibit our ability to move forward with our lawsuit, which is exactly what we want and what we need.
Yeah, and what's interesting, Alan, also is that I saw this non-party opposition to Karen Reed's motion. I checked the docket. I did not see your motion filed in the docket, which I understand Massachusetts does things differently, Mr. Jackson.
Very, very exactly. As Judge Cannoni let me know all the time, Massachusetts does things very differently. Yeah, there's an odd procedural aspect to civil filings, which is you file a motion. Sorry, my mistake. This is old school. That's what we do in California. You file a motion,
and every other jurisdiction in the country. Exactly.
But in Massachusetts, you serve a motion, you get service back from an opposition, and once you have that package together, you file both of those at the same time. It's just an odd procedural nicety in Massachusetts, and we followed that procedure. So that's why you don't see our motion on the docket, because once we served our motion and we received their very, very assertive opposition, then we said, okay, fine. If that's the position you're going to take, and you feel like it's not convenient or not consistent with efficiency to do these things together, we'll just file on our own. Next thing you know, as I said, we go back to court, and the O'Keefe parties, who are not the ones necessarily to oppose in that motion, but they were opposing it orally, said they changed 180 degrees and said, well, wait a minute, I think we need to consolidate these things, at least through the discovery process.
For discovery purposes.
Right.
Yeah,
right.
Exactly. And then, but what does it tell me? The fact that I didn't see your motion leaked, apparently, but we do see this opposition.
Well, it does tell you something. We didn't leak any motion, so it came from somewhere. I don't know where you got yours, but you didn't get it from us.
It's all around online, and maybe you think that
funny how that happens.
That little jab of they're getting ready to file a defamation lawsuit against Karen.
Yeah. Well, threats are just that. They're just threats. So we'll see.
Well, look, I mean, Alan, when I heard about it, potential, and this was reported in the news, by the way, before I even saw this, it was reported in some news article that they're getting ready to file this defamation lawsuit before I even saw this filing. Now that I saw the filing, I can confirm it. If this is accurate, of course, but I'm assuming it is that I just had one response. I've got 2 words.
I'll bet I know what they are. Yeah, do it. Knock yourself out. You be the best you can be. Yeah, I don't care.
All right. Okay. So let me ask you this. I mean, I know a little bit of civil work myself. I do a lot of civil work. So if I was the plaintiff in this action, I would be getting ready or trying to work out taking Karen's deposition. So is that what's going on? Is her deposition being scheduled? Has it been scheduled? What about some of the other people that you may have interest in deposing? Maybe you specifically have an interest in deposing. Have any depositions been scheduled yet?
So I'm not going to talk about, I don't want to get out over my skis. So I'm going to leave the civil procedure aspect of the case is being handled by She and Finney back in Boston. They're phenomenal lawyers. We've got an incredible team. Karen has an amazing team that's sort of running the procedural show, running the civil show back in Boston, and I don't want to get out over my skis and get ahead of them in terms of what they are or are not doing. I can assure you, from my perspective, are there depositions that I would like to be involved in? Yeah, you can imagine. You can imagine I would. Yeah, I'm a long way from being done. I haven't exhausted all the questions that I have. I'll put it that way.
Okay, great. Okay, fine. So let's move on from Karen Reed. I also saw recently we saw your letter about Commissioner Cox.
Right.
We saw you sent it to a number of different entities, I believe.
Two.
Oh, two. Okay.
Post commission and to Michelle Wu, the mayor.
Oh, okay. And we did see a response by the Post Commission sent to you.
Correct.
Yeah.
Correct. It was a very professional response. They basically punted, if I can put it that way. It was It was a professional punt, but it was a punt. They said, we have engaged the Boston Police Department through the city, and been assured by the city that the commissioner is not a sworn peace officer, which is interesting because I have a video of him being sworn in, and it sounds a hell of a lot like the exact same oath that police officers take. And the code says in Massachusetts that a peace officer is not only a sworn officer who's on the streets doing God's work, it's also the head of the agency or head of the department, and he happens to be that. He also wears a badge. He also has been seen and heard and recorded at commencement speeches, talking about himself as a peace officer, as a police officer, as a cop, making sort of euphemistic jokes about it. There's no question that the commissioner holds himself out to be a police officer, to be a peace officer. So I was a little bit surprised that the city took that position. I think as the head of the agency, he should be under the strictures of the Post Commission. They have the Post Commission Peace Officer Standards and Trainings is there for a reason. It's to establish a baseline for conduct of all officers. Why would he not be subject to that? He's literally the commissioner that supervises 3,000 people who are subject to those strictures. Why wouldn't he be? It seems like an odd position for him to take. But I was buoyed by Mr. Zuniga's letter, who's the director of the Boston or Massachusetts Post Commission. And he said he appreciated the letter. He appreciated my letter. He's taken it to heart. And they are currently reviewing their internal policies as to whether or not the Boston Police Commissioner in the future, moving forward, should be subject to post strictures. And I'm a little bit proud of that. If I could bring that to light and maybe change that policy, then good for us. But we're not done. He also said he would, under ordinary circumstances, forward my letter to Michelle Wu as a direct supervisor of the commission and the commissioner. But he wasn't doing that because I've already contacted her. So I already wrote it. Exactly. So you will probably find some follow-up by me and my staff and my office with Michelle Wu's office, and I will send a congratulatory and thank you letter to Mr. Zuniga for at least responding. I have not received any response from Michelle Wu's office, which is a little bit surprising as well. This is a serious matter, and I would think that she would take it seriously. I would hope that she would take it seriously, but maybe they're just backed up a little bit, and the draft is on her desk waiting to be signed. We'll see.
I'm sure it is. But I will say, I mean, anyone that has some sort of influence on their officers, telling them to do the right thing or not telling them to do the right thing, whichever you believe, definitely holds a lot of influence with their officers, calling them into meetings. You would think that they should be at least subject to at least whatever their officers they're influencing, the same standards.
Well, the code says, that's exactly right, Martin. The code says that a peace officer is defined as someone who is engaged in police work. How could the commissioner say with a straight face, I'm calling my staff in, I'm calling my officers in, staff officers in, and others, and giving them advice, giving them supervisory advice on how to conduct themselves on the witness stand? By the way, professional police officers are professional witnesses. That is part of the job description. You investigate crimes, and then you testify about the investigation concomitant to those crimes. So how could you possibly say with a straight face, I'm giving advice and counsel to my officers on how to do their job, except I'm not, that's not in furtherance of police conduct or the mission of the police department. Of course it is. Of course it is. So I think unfortunately, I think the city, not Post, I'm not laying the blame on Post because I think they did what they could do. Their hands are a little bit tied. The city has taken the position he's not subject to Post, so go pound sand. I think that's a ridiculous position to take. I don't think that it is one that would hold up under scrutiny, and I intend to scrutinize it a little bit.
Yeah, I mean, like, it's just another thing in Massachusetts. I mean, if the Karen Reed case has done anything, it's helped clean up a lot of the mess there, and
Right.
looks like the cleaning is not done, and you're continuing the cleaning process. So
right, as best we can. You bet.
Yeah, and it's funny, I actually had another attorney from Massachusetts on the channel talking about the case that we were discussing before with the bond revocation. And it was like a breath of fresh air because she's been practicing there for over 40 years, 50 years maybe, and she was saying how the judicial process there is not like what we're seeing now. Well, not like what's going on with Karen Reed, not what's going on with Turtle Boy. Like, this is not what usually happens there. Like, and a lot of people are feeling like, sheesh, is this what happens every single day in Massachusetts?
That's what it feels like to me. I got to tell, I would love to have a coffee with your colleague who said it's not like this every day, because every day that I've been there, it's been like this.
Yeah. I think with Turtle Boy also.
Literally, I have no other perspective. The prism through which I view the Massachusetts justice system, I'm like gobsmacked and shocked every day.
Yeah, I think we all are. Okay, so let's move on to Frazier Bohm.
Sure.
Okay, so for some of you who may not be familiar, Frazier Bohm is one of Alan Jackson's next cases, a defendant who we're going to hear some more details, I guess, that you'll break down for us. But let me first discuss the issue that I think the media is painting about who Frazier Bohm is, and maybe you can help clarify whether this is an accurate portrayal or not. And also maybe you can talk about a little bit about the difference between how the media portrayed Karen Reed throughout her trial and how the media is portraying Frazier Bohm. What I see right away when you look up Frazier Bohm is rich kid mows into 4 students and kills them. And then you see this tall, 6'4", 22-year-old handsome kid, looks like, that's a rich kid living in Malibu, driving a BMW. Like, his father probably got it for him for his 18th birthday. All the stereotypes that people are conjuring up in their mind. Now, this is just some rich, snobby kid who was going 100 miles per hour because he had all he cares about is himself, and he just rammed into these 4 girls and killed them. So is that the accurate portrayal, or what's really going on?
Furthest thing from the truth. Frazier Bohm and the Bohm family are portrayed in the media, as you said, as this rich, have not a care in the world family that they're spoiled. They have everything at their fingertips, and they're just sort of buying their way out of an allegation. Nothing could be further from the truth. Nothing. Have they been fortunate? Yes. Have they been more fortunate than some other parts of the country or some other parts of the state and other families? Of course. Are they wildly wealthy and can just afford everything? Absolutely not. As a matter of fact, what they spent their resources on, they lost a house because of it. They had a nice house. Yes, it was not a hovel by any means, but it wasn't a mansion either. Happened to be in Malibu, and he happened to have the advantage of a zip code. But he was not raised in the manner that is being suggested by the media. Not even close. They expended every single resource they have available to them to make sure that Frazier could get out. This extraordinary bail, which I made a pitch to reduce even further to something more consistent with what the law demands, and consistent with what the right charges would be in this case, which we'll get into in just a second. And that was met with a denial. Judge Rubinson said no. So he's out on a $4 million bond, which cost an absolute fortune. And that's where their resources went. They do not have the resources that they need currently, right now, for us to properly defend this case. It requires experts. Experts come at a cost. Testing comes at a cost. Their analysis comes at a cost. Trips to and from court come at a cost. Their time for their testimony. Every one of these experts does and deserves to be paid for their time. That is an enormous expenditure for anybody, including them, and they do not have the funds to do it. I can tell you this without getting into anything that's attorney-client privileged, but people think, oh my gosh, they just wrote a check to Alan Jackson and his team and the defense team, and they're just funding this defense. I'm not going to go into the details, but I can tell you that is not true. That is not true. That's not what happened. That's not how we got on board. So the idea that he's just some rich kid who was driving 100 miles an hour because he didn't have a care in the world is completely false. As a matter of fact, we'll get into the details about what actually the facts actually show in just a few minutes. People they haven't at this point dug into the facts of this case as much as they did, for instance, in Karen's case. There was an enormous appetite to get into the facts of what happened in Karen's case, and that appetite has been less so in this case. And I want to change that, because people deserve to know how their laws are being enacted, or if not enacted, at least executed. How their DA's offices are making charging decisions, how the police are conducting their investigations. It's no different here in California. We expect the same, and I will put the police and the DA's office under the exact same type of scrutiny that we did in Massachusetts. It's not relegated just to the East Coast. We're going to do the same thing here on the West Coast. And when we do, I think you're going to find that this is a very, very different case than the Nancy Grace's, for instance, who's more of a caricature of herself than a serious reporter. That those types of reports have been leveled. It's a very different case than that.
Okay, so just the first fact that I think we have to clear the air about is that this is not a rich kid who just has endless amount of money and, I can go hire Alan Jackson to pay whatever he wants. They put up most of their money to just pay for the bond.
Correct.
Right.
Nearly everything they've got to pay for the bond. And there are, again, I don't want to overstep and get into too much detail, but I can tell you that houses have been lost, 401ks have been sold. Everything that you could imagine you and your family, Martin, would do for your children, that has been done in this case in order to fund the at least the beginnings of this defense. And we haven't even gotten really good and started yet. They're going to have to go to the public for help. They're going to have to go to friends and family for help. They've already gone to friends and family for help. This is not a wealthy family who's sitting back with their feet kicked up on their desk and their hands laced behind their head, just throwing checks and credit cards at people. This is a family who is in dire need of resources to be able to mount a defense against the juggernaut that is the Los Angeles County District Attorney's Office.
Hey, this sounds like they did everything that Karen Reed did before, she had to go to her fund. So
Karen lost her house. She lost her job. She lost her teaching position. She lost her car. She lost basically, Karen, bless her heart, lost everything in order to mount the defense that she needed. And you tell me, Martin, you watched it. You think she needed every one of those resources? Oh, absolutely. She needed every dime of what she lost and spent, most of which was on, nearly all of which was on experts. Remember, we didn't do this. The defense team did not do this for money. Her case was an exception. Her case was a unicorn, and we knew that. And so we were happily willing to forego our fees in order to put the resources where they need to go, and that is toward the experts. And you tell me, watching that play out on live TV, if it was worth it. That's what
the experts won the case.
That's what it takes, Martin, to battle the prosecution. It's not just, everybody says, well, the Constitution says you're entitled to a defense. You are entitled to a defense. You're not entitled to a good one. You're not entitled to the best one you can mount. You're entitled to a defense. I take great umbrage with the idea, this young man who's now 24, he's 22 at the time, can just fund his defense because he happened to live in a zip code that was a high net worth zip code. He didn't happen to be one of those high net worth individuals.
Yeah. And speaking of experts, I think, very clearly in your case, you're going to absolutely need an accident reconstructionist, just like ARCA, to reconstruct this whole accident. I know that some of your allegations are that some of your defenses are that actually a car actually hit him first. So
Correct.
That's all to be
Correct.
reconstructed, with experts. And you can imagine how many hundreds of thousands of dollars that may cost, just those experts alone.
It may not be just like ARCA. Oh. It may be ARCA. We'll see. We'll see.
I'll tell you who it won't be.
Who's that?
Aperture.
Oh, Christ almighty.
That I know it won't be.
No, it will not be. It will not be Aperture. Bless their little hearts. No, they're not gonna. No.
Yeah. But on that note, I do want to let you know that I did get the link to Fraser Boehm's defense fund, legal defense fund, and I put it in the description. So anybody who's watching can help Fraser Boehm. We're going to hear more why you should help him, because he's facing charges. I think this is the classic case of being overcharged. In fact, I just heard a case in New York where somebody with a rap sheet as long as you can imagine, like 90 tickets before, all types of issues that she ran into. She was also speeding like 3 times the speed limit on Ocean Parkway, a residential area, which we're going to hear maybe similar to Pacific Coast Highway. And she rammed into a car who a mother was sitting in with her 2 kids. I believe 2 of them were killed on the spot. And she just got something like 3 years. Like that was like her sentence. So, I mean, we're going to see the difference in this case. Let me ask, but let's kind of
4 life terms.
4 life terms, exactly. So let's let me ask you the next question. Dead man's curve. Is this? I mean, that sounds to me like you're asking to kill someone if you're speeding there. So, number one, did this accident happen in Dead Man's Curve?
So let me disabuse you of another sort of misnomer that's been bouncing around the internet. There was a reporter very early on, before I was ever involved in the case, when it first happened back in 2023. There was a reporter who was covering the case, and I don't think it was malicious by any means, but she called it Dead Man's Curve. She said, "I'm in Malibu. This is Dead Man's Curve, well-known place, blah, blah, blah. Jan and Dean did a song about it, etc." That's not Dead Man's Curve. The song was about another road off on Sunset or something. That area of Malibu has never been referred to as Dead Man's Curve until this case. It is not Dead Man's Curve.
And I've seen it in every single filing.
Correct. And by the way, the prosecution has now started using the phrase, and it's just not true. There's no fact. There's no basis for that statement, for that label, if you will. But that notwithstanding, there are, just from a factual standpoint, I've lived out here for more than 30 years, and I went to Pepperdine, so I drove on PCH in front of Pepperdine every day for 3 years. And then many, many other times after that, when I taught at Pepperdine, when I was teaching trial advocacy at Pepperdine, when I would go back as an adjunct, I've been on that road hundreds, maybe thousands of times. People speed on that road as a pastime. It is not. And look, I'm not going to get up here and suggest, this is not a PSA for speeding. But I'm going to get into some granular detail here that is not popular to talk about in terms of speeding and what speed does and how speed kills. And, we've all seen the signs and the bus benches and the logos and all that kind of stuff. But I'm going to talk about the reality of what speeding is in our society versus what it is not. And I can tell you that on PCH, people speed all the time. If you're going, in most circumstances, if there's not construction right there and there's red cones or orange cones or et cetera, you're almost always going above the speed limit, including the people that were surrounding Fraser Boehm that night. They were traveling above the speed limit as well. How much above the speed limit? That's another question. That's a question for another day. But if we're saying, well, my God, he was speeding on PCH, ergo, he's getting what he deserved, that is wrong. That is factually incorrect, because everybody has been doing it for decades, not for years, for decades. Since cars could go above the speed limit, they've been going above the speed limit. And there's a flow of traffic issue. So Dead Man's Curve on PCH, first of all, it's not Dead Man's Curve. And second of all, is it inherently dangerous? All of PCH has a certain amount of danger because of cars that are parked along the roadway, right? There's not another, I don't think there's another freeway in the country that has that kind of setup where literally it's just a little yellow line and 6 inches off a freeway. PCH is a freeway. It is the one freeway. 6 inches off the freeway are parked cars and some pedestrians walking back and forth. That is an inherently difficult and inherently dangerous place or situation for the road to be in. However, that does not stop the fact, or that doesn't change the fact that plenty of people go above the speed limit on PCH with no ill effect. They don't crash. They don't kill anybody. There aren't deadly crashes on that stretch of road every single day. They're very, very rare. And we're going to talk about that in just a second.
That would be my next question, actually. I was going to ask you, now we're talking about how everybody speeds on PCH. You would think that there's deadly accidents there, I don't know, monthly, like what's it like there in terms of the stats of the deadly, crashes that happen on PCH?
I may have one of my very, very talented associates, Jacqueline Sperania, is doing a lot of the digging on the specific statistics related to this case. And I believe I'm right about this, that over the last, let's call it 5 years, maybe it's been the last 10 years, there maybe the numbers are under 200 or somewhere around 200 fatal accidents. You know how many of those have been charged as murder, by the way? Zero. Well, now one. Frazier. That's it.
And they're all charged as vehicular manslaughter.
Or nothing.
Or nothing.
Sometimes they're not charged because they're accidents. Sometimes these folks don't get charged criminally because accidents happen. When you live in a society where you're sharing the same space at damn close to the same time as hundreds of thousands of other people in a dense populous area like Los Angeles, you're constantly surrounded by dangers. Dangers when you're walking on the street, if you're bicycling, if you're skateboarding, if you're driving a car, there are dangers everywhere. And when you're in a dense population like this, accidents do happen. There are plenty of circumstances, most circumstances, in which there's a loss of life in a vehicular accident or a vehicular fatality. Most of those circumstances, there's no crime at all. It's just an accident. It's a tragic accident. And that's what we have in this case, a tragedy that if it's like a sliding doors, the movie Sliding Doors, everything had to happen exactly, almost to the microsecond, exactly, perfectly, tragically for those 4 young girls to lose their lives that night. If you move the time scale 2 minutes, give me 30 seconds on either side, those 4 young ladies would not have been injured because they would have been out of the way of their own car and the parked car beside them. But this is the nature of a tragedy, and this is the nature of an accident. What we don't do in this society is we don't subvert the practice of law for the practice of emotion. And that's what's happened in this case. It is emotional. It's devastating. It's devastating for the families. It's devastating for Malibu, for the Pepperdine community. It's devastating for all of us. It's devastating to Frazier and his family as well. But what we don't do in a civilized society is supplant emotion for the practice of law. And that's what I want to talk to you a little bit about.
Okay, so then that brings us to how this case was charged, perhaps how it should have been charged, and the decisions that perhaps went into why they charged him with murder. So they charged him with murder, 4 counts of murder, not vehicular manslaughter, which means that he's facing life, like you said.
Right.
And you would think that they did some sort of investigation into this. So talk to us a little bit about what type of investigation they actually did before they realized, hey, this isn't a regular vehicular manslaughter. This is a murder.
So first of all, that's a good synopsis. That's a good softball for me to hit. Their theory, which they propounded, the prosecution propounded in open court at the preliminary hearing, which is their opportunity. A preliminary hearing here in California, it takes the place of an indictment. So we have preliminary hearings, generally speaking, not indictments. And at the preliminary hearing, that's when the prosecution, with the judge, with the defense, with witnesses, it's a mini trial with a very, very different, very low standard. It's just a probable cause.
Probable cause. Yeah, we do that in Michigan too.
Correct. So the theory that they propounded for 4 counts of murder was speed equals implied malice. That's it, Martin. That's what they argued. It wasn't anything else, just speed. As a matter of fact, now almost famously, because I've made such a big deal about it, because you live by the sword, you die by the sword. The prosecution had an opportunity to come up with a theory of liability, and they did. And their theory was there is a speed above which it's got to be murder. Well, what's the speed? I don't know. Well, okay, so if there's a speed above which it becomes murder, tell me what that speed is. So I'm on notice as a citizen. I know what that speed is. I don't know. I don't have to tell you. I'm not going to tell you. I'm just going to tell you that it's at some point it's fast enough that it becomes murder. Well, as a citizen, I sort of need to know that. That's constitutional. I need to be on notice as to what it is that's going to put me in harm's way from a liability standpoint if I'm in a fatal accident, God forbid. What's that speed? The prosecution I'm being a little tongue in cheek, but it's a damn serious issue. The prosecution has yet to say it. What is that speed? All he said was that it's enough in this case. There was no, and so it's just speed equals implied malice. And I want to talk for a second. And that's why I like this forum, because it allows me to talk a little bit about the granular detail of the law. And this is where I want folks to understand what the prosecution's theory is. The prosecution has said he was just going too fast. That's it. Period, full stop. And because of that, it equals implied malice. There was no fleeing of a crime. There was no drunkenness.
Alan,
it wasn't on drugs.
Can I stop you for 1 second? Because I think that just for the benefit of everyone watching, you and I know what we're talking about, but just to explain the difference between vehicular manslaughter, which may include something like gross negligence, and you keep talking about malice, implied malice, maybe there's express malice. I think it would just be helpful to just kind of lay the foundation for everybody to understand the difference. And then I don't mean to cut you off, but then you can continue.
Yeah. So for manslaughter, it requires either negligence or gross negligence, depending upon the level of manslaughter. Vehicular manslaughter can be either ordinary negligence or gross negligence. It's beyond dangerousness. It's beyond something that's just ordinarily an accident, like you did something dangerous. It has to be negligent or grossly negligent in order to be criminalized and be considered manslaughter if a life is lost. Beyond that, the next step up, it's a huge step up, is murder. And there's two ways to get to murder, as all lawyers know. It's express malice or implied malice. Express malice means you have evidence that there was an intent to kill. You intended to take a life. That is clearly not what we have here, and nothing close to it. That's not what the prosecution is suggesting. There's no suggestion or intimation that Frazier Bohm intended to visit harm on any human being that night. Zero. So now what we're left with is this idea of implied malice. How do you get to implied malice? It's committing an act, and I'm going to talk about the contours of what implied malice means for vehicular murder, for what it's called Watson murder in California. But just as a predicate, it means you commit an act, the natural and probable consequences of which are dangerous to human life, and you ignore that danger. Right? That's the normal, the normal what was the standard for implied malice in California until 2023. A case called Reyes came out and it completely changed it. Now the standard is that there's an objective and a subjective prong. The objective prong of implied malice in California is no longer, did you commit an act that's dangerous and then you ignore that act and it costs someone their life? That used to be the law, which is a relatively low standard. It's changed to this. You have to commit an act that in and of itself has a, quote, high probability that it will cause death. Not a possibility, not a likelihood, and not just a probability, a high probability that your act will cause death, not is dangerous to human life. It's a very, very big difference. And the law changed precipitously in 2023 as it pertains to vehicular homicide cases, putting the burden far, far, far higher on the prosecution to prove a high probability that your act will cause death. So now the question becomes.
Now let me just ask you this question. I'm sorry, I don't mean to jump, but just to clarify for everybody, that is an objective test, right?
Correct.
So that means that what you're doing objectively and it doesn't matter what you're thinking. What you're doing will most likely probably result in death. Not that what you're doing is extremely dangerous, which would maybe be gross negligence. This is what you're doing objectively means that it most likely will cause a death. So driving fast.
Let me change that phrase.
High probability.
You've said correct. You've said most likely. That used to be the law. Now in 2023, it's no longer the act from an objective standpoint. Whatever you're doing, that objectively, it has a high probability that it will cost someone their life. Right?
So now talk to us about speeding on a highway. If that equals the objective factor that you need to get in order to charge someone with murder.
Not even close. Not even close. No, it doesn't. And the Supreme Court has, and that's not just coming from Alan Jackson. That's the Supreme Court of California. It says that there's never been a circumstance, there's never been a case in the history of California. And I told Judge Rubinson this. Like I said, I don't think you want to be the first judge to do this, to sign off on this. There has never been a case in California in which speed alone has been the predicate for murder under this incredibly high standard. That it's a high probability. When you speed on PCH, think about it. When you speed on PCH and there's an accident and it costs someone their life, that there's a high probability every time you speed on PCH that someone's going to die. Is there a high probability?
I mean, if that was the case, Alan, then we would have the stats right in front of us of how many deaths occur every single week or month, whatever, on PCH, which you're saying.
And they're not. They are not there. The stats do not bear that out. As a matter of fact, for all the people that speed, there's hundreds of thousands of people per year that speed on PCH, hundreds of thousands. There's a very, very small percentage of those people who speed on PCH every single year who get a ticket. There's a smaller percentage of people who get a ticket and cause an accident. And it's a minuscule percentage of those hundreds of thousands, maybe millions of people who speed on PCH who cause a fatality. Minuscule. So now you compare that. Now go back to what I said about the Reyes case in 2023, setting the standard at, so is speeding, given what we now know about the stats, is speeding on PCH an act for which there is a high probability that you will cost someone their life? The answer is no. As a matter of fact, there's a justice in California, a Supreme Court justice in California named Justice Evans. And she saw this problem and she saw it coming. And she said, prosecutors are getting too cute by half with these potential murder charges on vehicular fatality accidents or incidents. She said, and this doesn't come from me, these are her words, quote, and this is in a statement that she made. The Supreme Court of California can issue opinions, they can, and they're always published, or they can issue something called a statement, which is separate and apart from an opinion, but it's guidance to lower courts. This was in a statement. It's literally the Supreme Court of California telling lower courts, watch out, and be on notice about this issue. And this issue was the following, quote, speeding, even at a high rate, does not automatically equate to a high probability of death, end quote. I didn't say it. The Supreme Court said it. It couldn't be clearer. She's saying, don't start taking speed as the predicate to start prosecuting these cases for murder. They are not murder. That is not a high probability of death. If it's not a high probability of death, then you're back down to either gross negligence or ordinary negligence. And now we're back in the sane world of manslaughter, which is exactly where this case should be. And by the way, I am in no way saying that Frazier is guilty of manslaughter. We have a lot of ground to cover. And if we can establish, which I believe will be established by the facts, that this was a terrible, terrible accident, that is not criminal. Accidents are not criminal. But let's play on the right playing field, Martin. That's all I'm asking. I don't want to have to walk in with the onerous sort of Damocles over Frazier's head facing these murder charges at a trial. It's insane. That's not that is supplanting emotion for the practice of law. We should not be doing that.
So let me ask you this question then. I saw a number of cases. I was researching this for the show, and I did some research, and I found a number of cases where people were intoxicated or they were high on drugs. Was Frazier intoxicated at the time? Was he on drugs? Was he on prescription medication? What was going on in terms of that?
Not only was he gave his BAC that night. It wasn't like he was below the legal limit. He was 0.00, no alcohol on board, no drugs. He gave a tox screen, no drugs on board. His phone was checked, no texting at the time, no emailing at the time. He wasn't on his phone at the time. There was no distracted driving. There was no drunk driving. There was no drug driving, nothing. The only thing the prosecution has to go on is speed. And as Justice Evans said, that is not enough ever to justify, that alone is not enough to justify a murder charge. And that's why we're fighting so hard against this, because it is not the proper legal position for the prosecution to take and for Frazier to be in. Okay,
so now that we discussed the objective prong, if you don't mind, let's move on to the subjective prong, right? Because when it comes to malice, like you said, implied malice, it's not just that what you're doing is objectively so dangerous that there's going to be a high probability it will cause death, but there also has to be that you actively knew about it and disregarded it.
Right. That you knew what the danger was, and you said, who cares? I'm going to do it anyway. I know what the danger is. I know. And by the way, again, it goes back to, you can't have the subjective without the objective, right? Because you're taking the objective standard and you're saying, I know about that objective standard and I just don't care. I'm ignoring that whatsoever. So in this case, the analysis has to start and stop with, did Frazier do they have evidence that Frazier had in his mind that he knew that his act of speeding had a high probability that it would cause death? And he said, screw it. I don't care.
And I think you've effectively shown how the objective factor is not there. But what's their argument? Right. Well, what's your argument, even if they would say, well, I don't know, speeding, and somehow they'd make that argument, and I don't know, it was just a statement by the justice, and it's not binding authority, and whatever. So let's move on to the subject. So what's their argument? Just the fact that he knew that speed kills?
So yeah, that's their argument. That he was asked. They knew that they didn't have him for drunk driving. And I think that the police officers were highly charged. It was in a very emotional scene. There are 4 individuals who lost their life. I think there was a desire by the investigators to engage Frazier and find something. They wanted to find something. It's human nature. Of course, they want to find something, and they were looking under every rock, around every corner, and there was nothing. There was nothing to suggest that he was doing anything criminal at all. They checked his blood, they checked his alcohol content, they did everything, checked his phone, the whole thing. So then they finally resorted to, have you ever heard the phrase "speed kills"?
So I'm not as much, but once I was watching the hearing and reading the papers, I started seeing it more and more. But
so they asked him that. Have you ever heard the phrase "speed kills"? There's almost nobody who's got a driver license who hasn't heard the phrase "speed kills" or seen a billboard that says "speed kills." That's been a phrase that's been around for 20 years. So of course he said, "Yeah, I've heard that phrase," and that's what they predicated it on. They said,
"Well, they also said that he has these
speed kills. You're speeding." Yeah, he's got a couple of friends back in high school who died. Very, very different circumstances. Nobody quite knows what those circumstances were, but 2 friends died in a very, very tragic accident in a Tesla on a surface street, going extremely fast on a surface street. And so he hearkened back to that, and he said, "Yeah, as a matter of fact, I've got friends who have passed in accidents." Everybody knows that. The question is not whether you know that speed can kill. The question is whether you know that what you were doing was like. No, I'm sorry, I'm catching myself in the pre-Reyes language, had a high probability of killing someone, and you ignored it. What the evidence that they actually have is when they asked Frazier, do you know how fast you were going? His only statements, he made two statements, basically. One statement was, I think at some point I was probably 5 miles an hour over. And the other statements were, you know what, when he's pressed, how fast are you going? Did you look at your speedometer? Did you see your speedometer? Did you see your speed? His answer was, I honestly, I don't know. I don't know. I don't know. I don't know. So one of the postulates of the law.
After he just had a concussion?
He not just a concussion, a brain bleed. His brain was bleeding at the time.
So he's having a traumatic brain injury.
Correct.
And he's being asked these questions. And that's what they're using to show that he had this subjective prong was satisfied.
That's exactly right. Okay, and you can't, and Martin, you cannot, I mean, it is, it's idiomatic that you cannot disregard a fact that you don't know. And that's what they have to prove, that he knew of a fact. He knew how fast he was going. He knew that there was a high that at that speed, there was a high probability that he was going to kill someone, a high probability that he was going to kill someone. He said, damn the poor torpedoes. I don't care. It's all good. I'm just going to do it anyway. They don't have that. So apart from the fact that the prosecution does not have the predicate of the objective standard, they also do not have the predicate for the subjective standard. Under Watson, the normal way that the police and prosecution gets to a Watson murder charge is to prove the subjective factor. Traditionally, the Watson case, and the reason it's called a Watson murder, is the Watson case was a case in which the individual had either 3 or 4 prior DUIs. He had been warned over and over in a judicial context. You drink and drive, you could kill someone. You drink and drive, you could kill someone. You drink and drive, you could kill someone, over and over and over and over. And he had been punished for drinking and driving, including, I believe, in the Watson case, at least one of the 4 drunk driving incidents was also an accident. So the 5th time, he kills someone. And that was the predicate on which they based that he must have had the knowledge that drinking and driving that 5th time, you could kill someone, you do kill someone. Now you know of the danger and you ignored it. You actively ignored it.
And was that also
so different than
was that also the case? Sorry, was that also the case where he literally almost killed somebody 2 minutes before he killed someone? Like he slammed on the brakes in the intersection, or was that a different case?
Martin, that's a good question. I don't know. I don't want to sound completely ignorant, but I don't know. I haven't read the case in many, many years, but it wouldn't surprise me. The facts in Watson were pretty outrageous, and that's what built the predicate for Watson murder. And it's so rare. It is so unbelievably rare. It should be rare that when a vehicular homicide occurs, a vehicular death occurs, that we go all the way to the top of the ladder for murder charges. It should be incredibly rare. It should be absolutely outrageous conduct to support the charge for murder. We don't have that here. As a matter of fact, our analysis, and you talked about experts and what experts cost, we've just begun an initial analysis of the EDR data, the event data recorder. And that EDR data shows that about 2,600 feet before the accident, he was going the speed limit. So that's 0.5 miles. So in the 0.5 miles before the incident, where the prosecution alleges he was going extremely fast, they say over 100 miles an hour, although they can't point to the exact time or the details about why they came to that conclusion, because the EDR data, which we're now finding out, some of it is correct, some of it is absolutely provably incorrect. And the ultimate speed it will be disputed, heavily disputed. But let's take their theory let's embrace it for purposes of this argument. If he was going the speed limit 0.5 miles before the incident, something caused him to speed up. Well, we have our theories about what that is.
That's exactly what I'm going to get into next. So I do know that, and again, I was following the argument, and we're going to talk about. So just to catch everybody up, all these arguments that you're making right now was brought up in a recent motion and a hearing, which I watched. And this is called the 995 motion, which is where you're basically telling the court, hey, they overcharged my client. They charged him with 4 counts of murder and then 4 counts of vehicular manslaughter. The first 4 have to go. We have no problem. I don't think the motion even addressed the vehicular manslaughter. You were completely fine with that, right? So, but this is what the motion, these are all the arguments that you're making right now. And And so just to get, before we get to the judge's ruling on this case, what happened in that motion. So we're talking about the subjective. We're talking about speed kills. They also mentioned, which I thought was interesting, that, well, he knows PCH like the back of his hand, which I think you pointed out, or in the papers I saw, if he wouldn't have known it, they would have used that part of the argument to say that, like it's whichever way, it's a double-edged sword.
It's heads they win, tails we lose. Well, he didn't know the area and he sped anyway, and that's super dangerous. Well, he knows the area and it's super dangerous and he sped anyway. We can't win that argument, right? That according to them, which tells you it's a little bit of a Hail Mary for them.
Yeah, and then let's move on.
It's of no legal moment, Martin, whether he did or didn't know that particular stretch of road. This was an accident. You know where most traffic accidents happen?
Within like a mile of your house or something.
Within 1 mile of your house, which like the back of your hand. Because that's where you spend most of your time, going to and from your house. In any event, that's a throwaway argument, and it means nothing. It will mean nothing to the Court of Appeal.
Right. And now let's move on to this Calandra guy. Okay, because this is where they also said, well, look, there's this guy, I think his name is Victor Calandra, right? You know him. He, according, I was about to say the Commonwealth, but according to the state, he just was a good citizen warning Frazier, hey, you better slow down. You're going to hurt somebody. You're going to hurt yourself maybe. And you have a very, very different take on that.
There's exactly one piece of evidence. One. It comes from one source, and only one source, that Victor Calandra was warning Frazier Bohm about anything.
And it comes from Victor.
And that comes from Victor Calandra himself. So you have to take that with not a grain of salt. Just shove the salt shaker down your throat. So we'll see if that fleshes out. We'll see if that ends up being borne out by actual evidence that he was really warning. It's a very convenient fact for only one person to suggest. So we'll see. I don't want to get. I am going to leave something for the trial, and for the court, but we'll see if that. It is an interesting sequence of events, and it dovetails right into what our scientific data we expect is going to show, which is this idea that it's not an idea, the fact that he was going the speed limit just within a couple of thousand feet before the accident. What happened? What was that event that took place that caused him to speed up? Could it have been a road rage incident? Could it have been fear that someone was trying to chase him down? Could it have been something like that? Some triggering event that caused him to speed up beyond the flow of traffic. There's a second issue that experts are now, and by the way, did I mention that they didn't do an accident reconstruction? Martin, have we talked about that?
Well, we didn't talk about that, but I saw it in the hearing. Yeah, go ahead.
Yeah, the police didn't do. The one thing that's missing, there are 4 young ladies who lost their life. Frazier could have been killed and ended up with a brain bleed and traumatic brain injury. This was a massive, massive accident. And the CHP decided right then and right there, they had their person, they had their theory, and they didn't need to do an investigation. So they didn't. They did not do an accident reconstruction. And now we can't. When you do an accident reconstruction, it is an extremely complex, complicated undertaking. You're doing everything from friction analyses on the pavement to friction analyses on the tires to every inch of the car is looked over, every inch of the roadway is looked over, every scrap of metal is put back together, every piece of plastic, every piece of glass. Now I'm back to taillights and headlight piece fragments. For God's sake, I can't get away from this thing. You're putting all that back together to reconstruct exactly what happened. The prosecution walks in and says, he was going too fast, so that's 4 counts of murder. And by the way, just believe us, without doing any kind of a reconstruction on their own. So that is going to be a point of contention. And some of that is going to be borne out in terms of what other drivers were doing. For instance, there is evidence that the left side, all of the damage to Frazier's car should be on the right side of his car toward the right front quarter panel, because he hit a parked car or parked cars on the right side. There should be no damage on his left side, on the driver's side. But there is damage on his driver's side. How could that be? How could there be paint transfer? How could there be a deflected mirror? How could there be something that deflects the driver's side mirror almost to where it was torn off the car? It came in no contact with any of the parked vehicles. But there is evidence that there was another car to his left that turned into him and may have clipped him just before it sent him. He looks to his left. The road starts to turn toward the left. So if he continues to drive straight for just a few seconds without negotiating that left turn, he's going to veer off to the right. There's parked cars there, and boom. Could that be what happened? Is that what happened? Well, that's what we're digging into. And we've got evidence that suggests it's exactly what happened.
Yeah, and it's very interesting because I recall reading, I think in their papers, that they're claiming that it was caused by him smashing into the parked vehicle. That's how that left mirror, driver's side mirror, got damaged.
Good experts, a good accident reconstruction would establish that, but good experts that we're hiring, and if we get the resources, can continue to fund, they will have an answer for that. And I think we're going to find out it is inconsistent with the prosecution's theory that the left side of the car was damaged in the accident. It was not.
Well, that's going to be very important. But let me just come back to Calandra for 1 second before we get to the judge's ruling, because something that I noticed, I know you know it, but I'm just going to point it out anyway, is that he was contradicted already for what happened after the accident. He claims that he was just being firm with him and upset, but other people said, and I think it was the Ortiz women, they said that he was screaming at him and he was using profanity and pulling him out of the car.
Kill him.
What?
Threatening to kill him.
Yeah. So he was already, contradicting. There's contradicted what he said at that point. And that would only help to establish that maybe he didn't just politely roll down his window and say, "You better slow down, young man, because you may hurt someone." Right.
Exactly. And we should know, there's all kinds of data that we now know through the ARCA experts, et cetera, and Dr. Wolf, Dr. Rinchler, the folks that worked on Karen's case. There's all kinds of information that we can know. We will know when windows were rolled down. We'll know how fast the car was going, how fast the axle was turning when the right-hand electric window went down. Like, those are kind of data points that we're looking for. We can almost, with the right EDR data and the right experts, we can almost recreate an entire vehicular event. So if, for instance, a witness says, well, I pulled up to him at a stoplight and I gently put my window down and said something about, you're going too fast, and I warned him, et cetera. We'll find out. Did you put your window down and warn him? Or were you, is it more likely that you were giving him the bird and you were pissed off because you felt like you got cut off at some point? And road rage happens. I get it. Road rage happens. But if you do it, you got to own it.
And he claims that there was a previous incident. You spoke about this, that there's a previous incident where this exact person was involved in a road rage incident. He claims that he was the victim of it. He was not the instigator of it. Right. And I think you have a different take on that also.
We do. And we will explore that as well. That will be fully, thoroughly vetted.
Right. Okay. So after all of this argument in front of this judge that just recently happened, the judge most likely agreed with you, right?
I wish Judge Rubinson had. He didn't. Judge Rubinson is a very good jurist. He's a good judge. I take no issue with his judicial abilities. He's a very, very, very smart man. He was a good DA when he was a DA. I knew him then. He's a good judge now. But good people can disagree, and I deeply, deeply disagree with his holding order. He held him to answer. I'm sorry. He denied my motion to dismiss the 4 charges after he was held to answer by another judge, and said, I think there's enough here. He said, I'm not saying that the prosecution is going to win a murder charge at trial. I'm not suggesting that, but I'm saying there's enough to go to trial. and to maintain these charges. I disagree with that. I do not believe that we are on the right playing field. I think these 4 charges need to be dismissed, and we are going to appeal, which Judge Rubinson understands. It's part of the process. It's nothing personal against him, but we are going to appeal that decision and make sure that we take it to the highest level that we possibly can, because I think this case could make law in California. It is a novel theory of the prosecution to suggest murder charges in this case. And you know the old adage, when you learned it when you were in law school, Martin, I did too. Bad facts make bad law, right? Yeah. These are really, the prosecution should be very, very cautious, very circumspect about proceeding on this case with murder charges all the way up through the appellate system, because this is a very, very bad set of facts for them. I do not believe it will pass muster. And this is not the case that I would want. When you've got a driver who's just speeding, he's got no drugs, no alcohol, he's not driving up on the curb, not driving up on the sidewalk, and you're charging this guy with murder? Are you kidding? That's a bad set of facts for you. And if that's true, that could unwind a lot of what they try to do, the good work that they try to do in other cases, because it's going to be a very, very, very bad decision for them. By the way, I do want to mention this as well. There is I don't even know what words to put on it other than just fairness and consistency. There is a legal postulate that similar cases or similar crimes should be treated similarly. Similar conduct should be treated similarly. You know that. It's a constitutional predicate. We don't pick and choose selective prosecutions because emotion takes over. 3 weeks ago, and I mentioned this to Judge Rubinson, 3 weeks ago, there was a man in Los Angeles driving on surface streets, not on a freeway like Frazier was, on surface streets, going more than 70 miles an hour, driving clearly reckless driving, drove up onto a sidewalk, drove his car on a sidewalk, 70 miles an hour, struck 2 people, killed them, struck 2 more people, critically injured them, although they lived, then fled the scene, then fled the jurisdiction. He was caught in Chicago, extradited for vehicular homicide, brought back to Los Angeles, or is in the process of being brought back to Los Angeles to face manslaughter charges. How in God's name can these 2 cases exist in the same orbit? This is the same office. It's not even, I can't even argue, the case in New York. Well, it's a different jurisdiction. They do things different in New York or Massachusetts or whatever. It's the same friggin' office. And to me, that's outrageous. How do you get to the conclusion? Frazier didn't drive up on any sidewalks. He wasn't driving in opposing traffic. He wasn't drunk. He didn't flee the scene. He was completely cooperative. He wasn't drunk driving. He didn't have any driving record. Frazier Boehm has never received a traffic ticket. He's always been a good, safe driver by every single objective indicator. And yet he's facing 4 murder charges. The same charges, as I said in court, the same predicate charges, these murder charges, as Brian Koberger, who slaughtered 4 people in a dormitory. Granted, right. One's first degree and one's second degree. Who cares? Really, who cares? Murder's murder. Right? In California, first degree murder is 25 to life. Second degree murder, which is what Frazier's facing, is 15 to life. 4 of those life sentences back to back, your life's over. You're done.
Yeah.
You die in prison. 22-year-old kid. To me, it's outrageous. It's just outrageous. And that does not take away from the tragedy and the devastation that we all feel. Frazier is heartbroken. It's bigger than heartbroken. He's person broken about the devastation that's been visited on these innocent families. He understands the gravity of that. But again, this is not the practice of emotion. It's the practice of law. And we need to keep that in mind.
Yeah. Well, so the appeal is going to be, it was filed. And is the case going to be stayed now pending the appeal, or what's going to happen?
No, the appeal the writ goes forward. It's an interlocutory appeal, as you know, which means it's an appeal during the process before there's a final judgment. We have a certain number of days to get that appeal, but it doesn't stay the process. But Judge Rubinson's very, very mindful of what we're doing. He's very, very accommodating. He wants to get this case moving forward, of course, but he has not had his proverbial judicial foot on my throat as yet. I've been down that road, but he's being very accommodating, very kind, very judicious, and he's allowing us to do the appeal that we need to do. He knows that it's important.
Okay. Well, we hope that the right charges are placed on Frazier, and you can defend him as you would.
I hope so.
And just like that other case. And I mean, I think it's important for everyone to really know the real story, as you know, like the media, I think is very against him, and they're painting him in this very negative light. And I think that's why I guess it's helpful, hopefully important for you to come onto this show and let everybody know. And we'll be constantly following Frazier Bohm and anything that goes on there, and we'll be reporting on it also. So
that's why I wanted to visit with you about it today. I think you know at the very base level, you give a very, very, very fair representation to both sides on every case. You just follow the law, and that's what I appreciate. That's one of the reasons that it was an easy decision for me to follow up on your invitation, very kind invitation to come on. I appreciate it.
You know, what's funny is that you guys all don't know this, but our first conversation, when you actually, like, I couldn't believe that I was getting a phone call from Alan Jackson, but when you actually called me and you're like, you know, one of the reasons why I want to come on your show is because you're not just always patting us on the back. You're looking at the case.
No, not at all.
I was like, oh,
I've seen some clips of you being kind of hard on us.
Yeah.
What was Jackson thinking?
Exactly.
And I'm okay with it. I'm good with it. I can take criticism. My skin is pretty thick.
Yeah, no, I mean, as a trial lawyer, it is. It's just, you know, when you have plenty of people who just want to pat you on the back and say, hey, you know, everything that you're doing is perfect 100%. But you're willing to come onto my show. And I try to look at everything objectively, and I just do the research myself. And I say, hey, I agree with this argument, or I don't agree with this argument. You know, I was very clear about what I felt about the failure to object by the mistrial, whatever. And I didn't think that the appeal had a chance. I mean, I call it the way that I see it after I do my research. So, again, Alan, I mean, I'm so grateful and fortunate that you came on to my show as opposed to, I mean, all the other invitations that you had. I'm really humbled. Thank you so much. You know, I hope at some point we can do this again, but that's going to be up to you, you know, but I really, really, again, very much appreciate coming on the show.
Martin, it's been a pleasure. Thank you. Enjoy the rest of your Sunday. Go watch some football.
Thanks. Okay. You too.
All right. Take care, sir.
All right. Well, that's it. I do know we have some of the comments I want to get to, so we're going to get to some of the comments today. I didn't want to leave Alan up on, you know, while we're going through these comments. And I apologize if some of these questions are for Alan. I'll do my best answering them. If not, maybe I'll be able to send them an email with some of these questions that I can answer, and then I'll get back to you with the answers. But I do plan on covering this case as in-depth as I always do, doing the research, reading through the briefs, reading through the law on this, and reporting to you about what's going on in this case. Because I think Alan's got a very good point here. The fact that this is an overcharge, and you hear about the cases right and left about people that are driving erratically, killing people. Unfortunately, very big tragedy, but they have to be charged in the right way. And this is just an example of being overcharged. So let's get through some of the comments here. All the best for tonight. Thank you for Unbalanced Equation. We have another one, or this afternoon, UK here. Thank you very much. We have Ellen Fagerlund, good whatever time of the day, from Denmark. Appreciate you for joining us from Denmark. Emily C., Dear Diary, today's a great day thanks to BC and AJ. 100% agree with that. Unbalanced again, BC is a blessing. Appreciate that. Happy Sunday from Cynthia. Thank you very much for that. We have, would you please ask AJ if he would say subscribe to Brother Counsel in his Action Jackson way? Oh, I wish I would have had him on to say that. Kristen from Manhattan. Okay, we'll have to get him the next time to say that. Jen Helm, thanks. The truth doesn't flinch. As bad blank as it gets. We've got Casey. AJ, thoughts on the sidebar releases? Okay. Well, we're going to have to ask him that later again about the sidebar getting released. On civil law, please ask about his watches and how he chooses what to wear in court. I want to know more about his wristwatch game. Some good questions there. The road is called Dead Man's Curve. What does that tell you? So he actually explained that actually the area where he was driving is not called Dead Man's Curve, actually. So that's very interesting. That's one of the things that he wanted to explain to everybody. Thank you very much for Bit for becoming a new member. Look at this. Solomon Radner, the one and only Brother Counsel's Brother Counsel National Trial Lawyer. AJ, you're a freaking beast and an absolute pleasure to watch in action. Okay, hopefully AJ will see that later and he'll be able to get to that. All right. Well, that's going to do it for today. Glad you all joined us for this very important conversation that we had. And I'm hoping that he'll come on again. I mean, he's willing to come on this time. Hopefully we will get him on again. So everyone can go back, hopefully, and catch the end of your football games if you're still watching that. If not, you can always binge watch some of the Brother Counsel stuff. If you haven't yet at this point, please subscribe, like, and also one more thing. There are 2 links in the description. One of them is for Fraser Bohm. The other one is for the RCCS charity, which I am collecting for in order to play in, as you see that jersey hanging right back there, in the special tournament, a hockey tournament, but it's to benefit this very, very special charity. It takes care of cancer patients that are stricken with cancer, and it really helps their families out, provide the support that they need. They hold them by the hand. It's a great, great organization, really, really close to my heart. And anyone who's ever had a family member or friend who's gone through cancer, they know exactly what that means. So if you can, any amount is appreciated. So you got the Fraser Bohm Defense Fund, and you also have the link to RCCS charity game that I'm playing in. All the money goes straight to the charity. I don't get a cent of it. It goes straight to the charity, and they do amazing, amazing work. The link is in the description. Thank you all again for joining me on this Sunday, and we will see you next time.